I think we're going to go ahead and get started. I'm going to say welcome everyone and thank you for joining us for today's webinar. My name is Ann Russo. I'm the Executive Director with the Building Officials Association of Florida. And today we are presenting the Senate Bill 4D webinar. Your panel of presenters includes the BOAF Legislative Committee Chair Ron Lyseca and committee members Sergio Escunce and George Wiggins. We're not attorneys, and all comments here are just that. There are opinions. The information in this webinar is not a substitute for reviewing the legislative changes with your city or county attorney. Just a little housekeeping before we get started. This is a webinar. You can hear us, but we cannot hear you. If you have any questions during the presentation, type them into the question box in your Zoom control panel, not the chat panel. You can still chat, but type your questions for the presenters in the question box. We should have time for questions at the end. And this session is being recorded. We hope to have it available on the website later this week. Now, without further ado, let's turn the time over to our chair, Ron Lyseca.
Good afternoon to all. And as Ann had said, we have a couple of things about the fact that the document does not make any representation for all the different scenarios. And this is a conversation, and both George and Sergio are both George is retired from the building department with many years of experience. We're not going to tell you how many decades. And Sergio also with Miami-Dade. So we're going to tap on them on a lot of these different areas for their opinions and their wisdom with regards to it. First one we're going to touch is on roofing and the 25% rule change, which is the first part of 4D. And George, if you'd like to pick it up from there.
Okay, thank you, Ron. Welcome everybody to this webinar on Senate Bill 4D. It is a quite comprehensive bill, as you know, on recertification. And at the last minute, there was an amendment to the bill by a senator at the beginning of the bill that deals with changing the 25% rule with regard to replacement of roofing before you have to replace the entire roof. First, I'll quickly go over, and this resource is also available at our BOAF resources library, but I'm going to briefly go through what the short section of the statute says. And it states that notwithstanding any provision of the Florida Building Code to the contrary, if an existing roofing system or roof section was built, repaired, or replaced in compliance with the requirements of the 2007 Building Code or any subsequent additions of the Florida Building Code, and 25% or more of such roofing section or roofing system or roof section is being repaired, replaced, recovered, only the repaired, replaced, recovered portion is required to be constructed in accordance with the Florida Building Code and the one that's in effect at that time. The Florida Building Commission shall adopt this exception by rule and incorporate it in the Florida Building Code. And notwithstanding section 553-73-4, a local government may not adopt by ordinance any administrative or technical amendment to this exception. And of course, that's because this has been adopted by statute. And then with how it relates to with the Florida Building Code is that in section 1511.1.1 of the Florida Building Code, building not more than 25% of the total roof area or roof section of an existing building or structure shall be repaired, replaced, or recovered in any 12-month period unless the entire existing roofing system or roof section is replaced to conform to the requirements of the code. That's the current code as changed by this statute. I'll be going through the various bullet points and other details as we go along, and we may have Ron or Sergio jump in here too if they feel a need further comments need to be added. So again, the current 25% trigger or replacement requiring complete re-roofing is eliminated by this statute. And going forward here, the Florida Building Commission is charged with amending the rules of the existing building code, and this, in fact, is in progress. Partial replacement limits will require documentation to eliminate confusion, and as replacements will need to conform to the code requirements then in place. Local jurisdictions may not adopt any local ordinance that impedes or changes this statutory charge. Request for clarification that replacements required under this change must be spaced at a minimum of 1 year apart. Now that's not currently in statute, but that's being currently considered by the Florida Building Commission. So let's go to the next slide. The authority having jurisdiction must document what areas were replaced and adherence to them applicable to the code addition. Repairs to roofing section, again, under 1511.1.1 that's currently in the Florida Building Code, is addressed, and partial replacement can be done. The authority having jurisdiction is not responsible for conflicts with current HOA, homeowners association, or conditions, covenants, conditions, restrictions, and easements, or related restrictions with regard to aesthetics. The authority having jurisdiction is not responsible for warranty requirements for existing roofing and its coordination with replacements. Education, property owners should be encouraged. Contractors must be encouraged to make available information with regard to the partial or potential coordination issues to the property owner and supply detailed roofing data to them. Next slide.
George,
Yes, Sergio has a comment.
before you leave that slide, I just want to focus in on and add a comment on the roofing sections. Traditionally, we would say that an entire roofing section, which could be bound by ridges and valleys and the eave, would need to be replaced entirely. This changes that. In other words, if you only have to re-roof or repair half a roof section, that's all you're bound to do. That's all the insurance company will pay for. So just keep that in mind, because that is a major change from what we currently do under the existing code language. Thank you, George.
Yeah, yes, that is. That's an important point that Sergio has made there. The updated, you might need to, and we would strongly advise updating your permit form under this rule to clearly note that detailed roofing diagram for replacement, any sheeting and water barrier replacement requirements are documented. Preferably, this would be best by a supplemental sheet so that you're not having to revise every single permit to include this, but that is strongly recommended for clarification in your jurisdiction. State coordination of differing roofing requirements between the existing and replacement are the full responsibility of the contractor. Inspections under this approach should include clear notations of what, where, and any observed transition points as part of the documentation to be archived. And this will be especially useful for those buildings that are covered under recertification. So that basically covers the changes in this new statute related to the 25% rule for roofing. So with that, I'll turn it over to Sergio or Ron to go forward with recertification.
All right, I'll kind of kick this off here, George. Thank you very much. The recertification, the Bill 4D, which has 80 plus pages on the recertification, deals with buildings that are 3 or more stories and defined as condominiums or co-ops. And these will require an inspection under the select requirements at defined intervals. Now, specifically, the statute excludes single-family residences such as single, duplex, or triplex, which are up to 3 stories in height, and these are as defined by the residential code in addition to the statute. So if you have a triplex, which may be 3 stories tall, that is excluded and is not required under this statute to be inspected under the phase 1, phase 2. With buildings that have a certificate of occupancy dated on or before July 1st of 1992, you must complete a phase 1 inspection by December 31st of 2024. If it is not clear what the certificate of occupancy date is, you use the best available occupancy information on file to determine that trigger date. Now, the database for the condominiums under 718 and co-ops under 719 is to be secured by DBPR through its applicable department. And by statute, the condos and co-ops must submit information to DBPR by December 31st, 2022. And this includes the fact that if you have an association that has multiple buildings, which all of them may be under one association, or you may have multiple buildings, each which have their own independent association, all that information has to be forwarded to DBPR to create the database. DBPR is then going to compile and make that database available. However, this is a moving target, and right now they have not set the date when this information would be available for downloading, both to as a general rule, plus of course the critical one is to the building department so they can construct their databases. Unfortunately, a lot of the property appraisers do not have the information with regards to which association has which building. So therefore it is critical that DBPR get this information compiled and make it available. The information to identify each building with a complex controlled by the association is critical because obviously you need to notify the right party. As far as notifications, and Sergio, you want to jump in on this as far as the, because you can give practical experience with regards to this.
I do, Ron. And before I go into this slide, let me go back to the previous slide and make a comment, which is important. And that has to do with bullet point number 2, the July 1st, 1992 date. That is established because for the 30-year properties, and we have to be reminded that there's 2 tiers. There are inland properties that start their recertification process at 30 years, but there's also coastal properties that start their recertification cycle at 25. The significant with 1992 is obviously today we're in 2022. So 30 years back, those are the 1992 properties that all those buildings on or before July 1st, when the act, when the law took effect, or actually when that date is slated within the bill. Those are the catch-up years for all buildings built prior to July 1st, 1992. What the law fails to mention for the 25-year properties is actually that date has to also be July 1st, 1997, because again, 2022 minus 25 years is 1997. So it's an important for you all to know that even though it's not in the law, the 25-year properties on or before July 1st, 1997 are also part of that transition or catch up, which are all due by December 31st, 2024. So keep that in mind. Okay, so then the next slide, Ron. So notification. So there is a requirement for local jurisdictions to send out notifications to condominium associations, not the condominium unit owners, but the condo association, which means that you have to acquire the contact information for your condo association. Now, as Ron stated, the state is working on that database, which is going to be ready by the end of the year. But until then, you may have to then acquire some of that contact information so that you can start doing that. Now, for inland buildings, the initial recertification cycle starts at 30 years. So when a building, 1993 building and forward, turns 30 years, they'll be required to do their initial recertification, and then every 10 years after that. For coastal buildings, then from the coastline, from the defined coastline, 3 miles inland, then you would have to identify those buildings that would be required to have a cycle of 25 years initial, and then every 10 years subsequent to that. So on both tiers, the subsequent inspections occur 10 years after their initial recertification and onward. And of course, one of the best ways to do it is to create some kind of a database to track notifications. This could be as simple as using an Excel database, or obviously, if you develop something that's more robust, that can do a lot more for you, then eventually that can be your database for that. Next slide, Ron.
Got it.
So your recertification reports. So within 180 days from your notification, the condominium associations are required to submit a phase one. So a phase one is basically a visual inspection, and you'll go in there and you'll see the definition within the law. But basically, a phase one is an examination of all habitable and non-habitable areas of a building, including the major structural components. And that is going to be done by a Florida licensed architect or engineer. And we understand that the board is developing a category for structural engineer. That's not part of this. Any licensed architect or any registered engineer can perform these inspections for a phase one. And then the phase one is the one that must be submitted to the local jurisdiction within that 180 days. The phase one report itself, there is a brief of what it needs to contain within the law. In essence, they have to provide a summary with at least the material findings and the recommendations. Of course, the report has to be signed and sealed. Electronic signature is allowed if they submit it to you electronically and it's a verifiable signature. It needs to indicate the manner and the type of inspection forming the basis for the inspection report. It needs to identify, substantial structural deterioration, and that's a defined term within the law. It describes the extent of such deterioration and identify any recommended repairs. That is the phase one report. Next slide, Ron.
You want to finish on the phase two, because the slide has a comment about the additional observations and testing that may trigger a phase.
I got it. So if your phase one does identify your any substantial structural deterioration, then a phase two is required. Otherwise, a phase two would not be required. And again, a phase two looks at required if it may involve destructive or non-destructive testing at the inspector's discretion. It may be as extensive or as limited as necessary to determine the building is structurally sound and safe for its intended use. And of course, that's the outcome of that report. The next slide. All right. Ordinances. So a local ordinance is not stated as being required, but it is strongly recommended. You're going to find that building departments may need to codify fees that need to be charged for this new task as allowed by statute. So that's done through an ordinance. Also, if you need to, if you want to be stricter than any of the minimum requirements of the law, this is the place to do it. So in other words, the law minimum, for example, gives 180 days. If you want to reduce that time for submittal of phase one, you would have to do it through an ordinance. If you wanted to, if let's say, for example, that you're in a jurisdiction that has both tiers, 30 inland buildings and coastal buildings, and you simply just want to extend the coastal building requirements across your whole jurisdiction and say that every building within your jurisdiction gets a recertification at 25 years, which obviously that would remove having to identify specific locations, you would have to do that through an ordinance as well.
Joe, can I make some comments? This is George.
Go ahead, George.
Yeah, this can be extremely important, and it can be extremely helpful to the local authority having jurisdiction, to the building official, to the building department, because this would give you the opportunity to craft your ordinance on implementing the provisions of this bill in the manner that's most helpful for your jurisdiction. Every building department jurisdiction in the state should have ordinance in place already with their administrative provisions of enforcement of the Florida Building Code and the creation of any board of rules and appeals or other items related to this. And this does give you authority to charge a fees for these services. And that falls under the fact that these provisions will be enacted by the Florida Building Commission as part of the Florida Building Code. So under the Florida Building Code, statute clearly authorizes local governments to charge fees with regard to enforcing the Florida Building Code. I just wanted to add that information. Thanks.
Excellent. Thank you, George. So we talked about creating a database for tracking, and it's important because there are certain milestone dates. There's the 180. There's also, as we'll see in a few slides ahead, there's also 365 days where repairs, if you have a phase 2 repair, that it has to start. So you have to be able to track your notifications, your reports, and your dates. So obviously, creating some kind of a database is important. And of course, there's forms. While the law does not require the building official to create any forms, it really leaves it up to the design professional to establish their own report mechanism. That's going to create a lot of inconsistency, and maybe it's not the information that you're looking for. So you can create your own forms. You can adopt them. Down here in Miami-Dade and Broward counties, we do provide structural forms that get filled out for consistency purposes. Of course, any information that is archived becomes part of the public records. You do have to be careful with public buildings, though. Remember that the statute, there is limitations to information that is available for public buildings and critical facilities. Some of these reports may include photos, and maybe the photos are not appropriate for release without proper authorization. Forms need to be archived and kept. They need to meet the records retention in the law. And then, of course, training of your personnel is important as to what to look for that is consistent with what the law requires the design professional to report on. And this is all new to us. So this is important that proper training and knowledge of the law is acquired early on.
I can add one thing, Sergio, to give emphasis is the archived information with regard to the as-built, because obviously anybody who's going to carry out a phase 1 inspection is going to need access to what the building plans were, where the as-built were, in order to start off with that. And we have to make the unfortunate assumption that a lot of these associations probably do not have all that information at their fingertips or even know where it could be located. So it's important that the building departments understand that this is going to be something that is going to be requested by those professionals in order to do their work.
Thank you, Ron.
We got the next slide.
Okay, so recertifications and actions related to a phase report. So your phase 1 report filing would require review that is done by a Florida licensed architect or engineer, detailing the inspection. And of course, as I mentioned before, it needs to be signed and sealed. And this is part of the archive that each community is going to require. If a phase 2 inspection is required, then notification that such is required with due dates noted in database uploaded. And remember that, and then under a phase 2 filed report, you're bound to find a requirement for repairs. And many times these repairs are going to require permits. And keep in mind that if on any threshold building, 4 stories or taller, this would require a special inspector to be involved in those repairs. So keep that in mind, that is going to be part of your building permit that you're going to issue for repairs. And of course, notifications to the association that select repairs may require permitting and inspections by the department and noted in the database to verify that they are pulled. So again, the database is critical to make sure that there's a follow-up to this mechanism.
Sir, here, one question that could arise, and I'm going to pose it right here and now. If you have a phase 2 report and the architect or engineer that is conducting that says these repairs have to be done, and it's a requirement for a special inspector, obviously that particular professional cannot serve that dual function.
Yeah, I would say that the special inspector would obviously has to be credentialed with the state as such in order to be able to undertake those repairs.
And
the
could not
inspections of
be
those.
yeah, and it couldn't be the same person that did the phase 2 report, obviously, because you want independence.
I think that's healthy.
Yes. Going along to our next slide, the enforcement. And this, I think, is something that both you and George can kind of touch on and give some commentary.
Okay, George, did you want to get started?
Okay. There's nothing clear in the statute on how they want us to enforce this, but typically with regard to building code actions, jurisdictions will have types of enforcement boards. It might be a code enforcement board, it might be a magistrate, but what I strongly advise is that you huddle with your city or county attorney for legal guidance on what would be the best mechanism for your jurisdiction to follow with regard to enforcement of these new statutory requirements for recertification of buildings. Since this is going to be a totally new area of enforcement for local building departments for 90% of the building departments of the state. Some jurisdictions have an unsafe structures board as well that would be the logical place to take enforcement action that was not followed up by the condo association or co-op. So those are some of my recommendations.
And I'll just add to that, George, that so what if repairs are not completed? And remembering that the law does require that repairs must be started within 365 days for a phase 2, then basically it becomes an unsafe, because one of the provisions in the law is that if repairs have not commenced within the time frame, then the local enforcement agency must review and determine if the building is unsafe for human occupancy. So after this time frame, you basically have the building official going out to this building, determining if indeed it is unsafe, which means you take unsafe structures action on it. And you go through that proceedings, which hopefully your local community has. Otherwise, you can also, determine that you may need to disconnect utilities to kind of enforce it. And this is kind of a dilemma that we have down here in South Florida as well, in Dade Broward, is that you have a building that has not obtained their recertification when due. And do you declare it unsafe? And that's really your only action, because in essence, they're past due, and it's undetermined whether the building is safe or unsafe. So you have to take action as an unsafe situation and try to at least, come into some kind of agreement. If it's an issue with funding the repairs, a lot of times you'll find that in condominium associations that they just don't have the reserve money, especially at this point. They don't have the reserve money to conduct the repair. So I think there's got to be an agreement. There's got to be a design professional involved saying that the building continues to be safe and can be occupied while repairs are being made. So that's certainly something at the discretion of the building official that can be accepted. And of course, there's the DBPR is the one that's going to manage the registry list of condominiums when it comes to that, and then you obviously have to consult your attorney, your city attorney, county attorney, about anything further than that.
And we do have a quick poll in here if you want to address that. As far as condos and co-ops 3 stories or taller, do you have any or not? And we're going to take about a 15-second pause while people answer.
Mhm.
Meanwhile, I am going to hit and go to the next slide so we can keep going and leave as much time as possible for our questions and answers.
All right, I'm watching the numbers on the poll go up, so I know people are still answering it.
Okay. Okay. Common questions on, ooh, that's a good one. 150, 85% of the people say, yeah, we got some 3 stories or taller. Yep. Yep. So thank you very much for your responses. Recertification. These, we came up with a couple of common questions. And Sergio, I'm going to tap you with regards to the coastline definition because that's a doozy. And you can.
It is, Ron. It is, and this is really going to be this is going to be a challenge because we're trying to plot it down here in Miami-Dade County because first of all, you need it to understand where that line is drawn for your 3-mile limit, and then identify those buildings that fall within that area. So basically, the definition of coastline means the line of mean low water along the portion of the coast that is in direct contact with the open sea and the line marking the seaward limit of inland waters as defined under the Convention of Territorial Seas and the contiguous zone in 15 UST Part 2, 1606. That's the technical definition. When you go into that, convention, when you go into that document, it's actually a definition that dates back to 1958, where all the countries define what the international waters or what the waters that pertain to the states, to the countries were. However, in plotting it, it does say that it includes all rivers that have they're affected by tidal water. So in essence, if you were to trace the mean low water line along those rivers inland, you can have some of those rivers extend that 3 miles considerably. I don't believe that that's the intent of this legislation. I believe the intent is to draw a line along the coast. And I think that the limiting factors is at the beginning of the definition, which means that it's the portion of the coast that is in direct contact with the open sea and the line marking the seaward limit of the inland waters. We are trying to get some guidance on exactly what this means. It's almost preferable that the state provide this map, much like they do with the CCCL line. In fact, if they would have selected that line, we would have already known where that line was. But unfortunately, they selected a different line. So it's important because it's also a matter of liability. If you draw this line wrong and it traverses a building, you can be contested as to
if it's applicable.
Should it be coastal or not? By the same token, if the line should have been further inland and you didn't include some of the buildings that should have been recertified earlier at 25 years, that also could present a liability. So stay tuned. I think we have to get more information on this particular issue, but it is important. And but for those coastal communities that are well within this 3-mile limit, then you really don't have anything to worry about. You're most likely going to be a coastal community and do all your buildings at 25 years. Ron?
And I'll take a couple of those other questions because we hand back off. Can you charge fees? The answer is that is what your ordinance is for. You actually are going to have an expense. So obviously, you need to charge a reasonable fee for these particular services that you're going to conduct, including the making sure that they file all their phase 1, phase 2 reports and related. As far as archived documents for reference, again, I'll go back to the as-built. You're going to have those for information. You have to be available. You have to make sure that you have that information as to how to access them and the fees related to them, depending how they want them. And as far as the carry out the inspections for other than phase 2, you are not going to carry out any inspections under a phase 1 report. That is the licensed architect engineer that's going to do that. The only ones that you're typically going to have to be involved with as far as inspection requirements will be those that are required under phase 2 that have to be permitted. Other than that, you don't have to.
Mhm.
Last but not least, I'm going to clean this up. Do we have to make the phased reports available to the public or the association owners? By statute, that is the responsibility of the association. And they are required to make that available to all of the unit owners as well as prospective buyers. You're probably going to have them, obviously, you're going to have them filed. Can the public request them for you for duplication? Obviously, it's public information. However, please make them aware that it's their association who is the primary responsibility to give them this information. And then we have a poll on milestone inspections. And hopefully another 30 seconds. I'd like to move on, leave as much time as possible for our Q&A portion. This is where we all take a deep breath.
So
Yes.
Ron, while the poll is being taken, I want to mention
Yep.
something that maybe
Go ahead.
hasn't been realized by a lot.
Mhm.
And it's what I call mapping the different data sets that are involved in the variety of buildings.
Ooh, we have a few people that have milestone inspections.
Already. How about
Welcome to the Shock of the Year Award, courtesy of the Florida Legislature.
So mapping your data sets, and you have to realize that there are at least four sets of data that we have to be concerned with. Two of them are what we call the transition buildings. Those are the buildings, the 30-year inland buildings that have dates prior to or after 1992. That's your 1983 through 1992. That 10 years worth of buildings, those are your catch-up years. And those are the ones that need to basically certify by December 31st. Then there's also your transition buildings for your 25-year buildings, which are the ones that are on or before 1997. Those are also due by December 31st, 2024. So that's two sets of databases or data sets that for transition buildings. Then there's the normal ones. This is the first time buildings that are going to be the current ones. So starting in 1993 or coming January, all the buildings that turn 30 years, 1993 and onward, those are new, and those will be due December 31st within the year. So for the 1993 properties, by December 31st of for December 31st of 2023, the 1993 recertifications are due. Likewise, if you have coastal buildings on a 25-year time frame, next January 2023, you're going to start with noticing 1998 buildings. And those will be due by the end of the year, December 31st, and so on. And every year after that, you're going to be notifying all those buildings that turn either 25 or 30. And right now, I know it's mind-boggling. It took me a while to kind of work this out, and we'll continue to work on it. But just so that you understand, it's not a straightforward thing. There's several data sets that have to be derived. That's why a database is important. You're not going to be able to do it just on the CO date. You'll have to actually build a database on the record level.
And that's one of the emphasis we said about the database, that you need to create a database, which means that a lot of the jurisdictions are going to have a friendly conversation with their IT department, see what their current software will allow them to do, and if it's necessary for them to either modify that software or have a separate software package just to deal with this. So that is also an expense. That's why you have to be able to charge some fees to defray all these additional requirements that have been created by statute. And we have the poll for the coastal and inland buildings up. So we'll give it about another 30 seconds so we can move on.
Mhm. This is George. I'd like to just say that what Sergio is pointing out about these four different scenarios is extremely important. And as we go forward, we ask for your assistance in identifying these, and because this is a totally new area of enforcement for many building departments.
We have have a few people, about 47% say they definitely have coastal. And of course, that's not that surprising.
Hmm.
Okay. Moving right along. Recertification items not related to the building departments, but I'm going to kind of take these. As I pointed out before, the associations are the one that have to make the phase 1 and phase 2 reports available to the owners and prospective purchasers under the specific media note or under statute. In some cases, depending upon if they're large enough, they actually have to post them on their website. The associations also have to carry out structural reserve review and update these every 10 years. Make sure they have the reserves for replacement and repairs as needed. And this information has to be made available to owners and prospective purchasers. But that is not required to be filed with the local jurisdictions. And those requirements are enforced by the state, not the local jurisdiction. And my key point is you need to educate your personnel. So when people come in, which are going to be confused, you can tell them where they have to point their request at versus the building department or the particular jurisdiction, whether it's a city or a county. Now we have some resources, and all of these are available. We have put the ordinances. We even put a copy of the enrolled Senate Bill 4D in the legislative resources, which is on the non-member side, so you can access that. And we will have other information available and also a copy of this handout. And moving right along, it's Q&A time. So I am going to ask our fearless leader, Ann, to start feeding us the questions so we can try to address as many as possible.
All right, there are a lot of questions. All right, I'm just going to kind of zip through some of them because there's so many. And so is this change to the 25% trigger effective now?
Yes.
If not, when?
Yes,
Now.
it was effective when the governor signed it, which was before Memorial Day. So guess what? It is now law, and you have to deal with it.
May 26th, magic date.
All
Next
right,
question.
what happens if the roof was built under the 2007 Florida Building Code or after, but is found through inspection to not be in compliance, maybe not built correctly in accordance with 2007 or newer code?
George, you want to tackle that one?
Say that again.
What happens if the roof was built under 2007 FBC or after, but it is found through inspection to not be in compliance, such as not built correctly or in accordance with 2007 or newer code?
Well, I guess there's a couple of avenues you could take. Yeah, I mean, you could take them you could direct them to bring it into compliance and appeal it to your appeals board, or ask them for what corrective measures they can take to bring it into compliance. You could look, certainly need to look at your records of inspections. Was it inspections and items missed? But most importantly, consult with your city or county attorney on the best mechanism legally to go about correcting it.
Okay.
I agree, George. I think it becomes an enforcement issue for the rest of the roof that is not the repair portion that they're citing there.
Yeah.
Right.
Go ahead, Ann.
All right, how are we to address compatibility differences between shingle manufacturers?
I'll take that one. Basically, this is an issue that the particular contractor that is going to pull the permit is going to have to address and document as to how they are handling that. It is going to be an issue. You have a 15-year-old roof and you're replacing it with shingles today. Even the same manufacturer may not have the same product available, or the recommendation for installation may differ. So this has to be a decision, and it has to be documented by the contractor doing the repair work. And I'll be honest with you, I think this is going to raise warranty issues. And again, that is not under the providence of the building department. That has to be documented and resolved by whoever is going to do that. So they've opened a little can of worms. Next one.
Does the elimination of the 25% rule apply to older roofs installed prior to the 2007 FBC?
I'll handle that one too, George. I'll leave you for the harder ones. No.
Okay.
No, it does not. If the statute specifically says 2007 or later, so if you have a roof that was done in 2005 and they want to try to replace part of it, the answer is the old rule with 25% still holds, which means that if you have a roof and it's 30% of it was damaged, they have to completely replace it, which means the insurance company, if it's an insured building, will be on the hook technically. And again, they're going to try to weasel around it, but that is the correct interpretation. It does not apply. Next question.
All right. What if it's 5 units, but only 2 stories?
One more time.
What
It's
if
not-
it's 5 units, but only 2 stories?
The statute says single, 2, and 3 family. If it's 5 units. Okay, Sergio, you want to tackle that one?
Yeah, I think the trick is here is it's only 2 stories. So
Right.
recertified buildings start at 3 stories and
And
up.
Above. And the
Oh.
only, yeah, and the statute said if it's 3 stories and it is single, 2 or 3 family, it is exempt. So I think if it's 2 stories, you're still under the residential code and would not be covered by recertification.
Right. That's correct. It doesn't meet the 3-story threshold to begin with.
Okay.
All right. So 4-unit condo that is 2 stories is not included, but a 4-unit condo that is 3 stories is required to have the phase inspection.
That's
Yes.
it. As long as
Yes.
it's a condo or co-op, 3
Correct.
stories or taller. Yes.
Correct.
All right. What is the statute reference for recertification?
4D is the bill, and the bill cites different statute references. So please review that because 718 is involved, 719, 553 with regards to the building or the licensing for those that are required to do or are allowed to do the phase 1, phase 2. So there's several citations there. So there's more than one statute involved.
All right. So, and we did post the bill text for 4D on the legislative resources. It was the link is in your confirmation email you should have gotten today also, if anyone's looking for that. Okay. Can an architect do phase 1 report for a threshold building?
Yes.
Florida licensed.
A Florida licensed architect or engineer.
All right. Is the building condo owner association waiting for the building department, or do they need to act sooner rather than later?
Arlene, I'll tackle that question because if the local jurisdiction has a database that knows who the association is, they are required to send out the notice, and the condominium or co-op must comply within 180 days to complete the phase 1 inspection. The condo association obviously could wait until they get the notification, but I would say start planning because, as Sergio pointed out, the magical 92 year, that can be buildings that were built in 1970 that are going to require certification. And in some jurisdictions, you could have several hundred buildings that are affected. And it's going to be fun to get people to go do that because you have to have the experience to tackle this as a professional to be able to do that review because there is a liability issue involved. Next question.
All right. Are electrical safety inspections part of the 25/30-year phase 1 or phase 2 recertification inspection process?
No, only structural.
The phase 2 could be. If they see something, obviously, that is an issue that could be written up under the phase 1 and require a phase 2 inspection, but not under the phase 1.
All right. So I'm going to combine a couple of different questions here. Will there be a draft roofing memorandum and guidance provided by BOAF to the jurisdictions to help aid uniform compliance across jurisdictions, similar to the model chapter 1? And then another question similar, is BOAF going to create a template ordinance?
Put that in your comments on the survey that you're getting, because this would be useful and we can discuss that with the proper work group and see what we can do.
Yeah, I would say, yes, we would make an attempt to have a BOAF document, a model that would help building departments to uniformly respond to this, but we'll take a little while yet to see what kind of language the Florida Building Commission ends up with.
So stay tuned.
Are there any recommendations on a fee schedule for this process, or who would get charged for admin and monitoring by the local jurisdiction?
George, that's one of your nice little areas of commentary.
Well, there's many different methods for look at fee establishment. Again, it's going to vary widely because of the size of different building departments and the extent of time and how closely they're following a model. There's just so many factors in it. We've always followed a model of putting on a percentage with our construction valuations, but whether it be applicable at all, might relate to the value of the professionals that are doing the reports and what's going to be required in documentation. All that has to be taken into consideration. So there's not a perfect answer for that, but would be up to the jurisdiction, and it's would be empowered by our statute.
All right, I think a part two to that, ideas on when to charge the fee and how to collect if a homeowners association won't pay or condo association won't pay.
Well, you should begin immediately looking at that, and if it's going to take your time and resources, then a fee should be charged as soon as possible. Again, the timing, it may need to be changed further down the road based on the number of buildings impacted and condo associations, but I would recommend acting pretty quickly.
Sergio, I'm going to tap on you because Dade County and Broward have been doing it for a number of years. You have a specific form that they have to complete and they have to pay at that time. Is that correct?
When they submit the reports, they have to also submit payment upfront. Yes.
Okay. Next question.
All right, what does type of inspection actually mean? Visual, structural, electrical?
Phase one is a visual inspection. And if you see some issues, you document them. Phase two is a more intrusive inspection, which could require either destructive or non-destructive, and would require more time from the licensed professional to document what really is there, and then the recommendations on what repairs are required. Sergio, you got any comments on that one?
Yeah, I would say that the intent of a phase one, phase two is you get the phase one and you submit it up front early. And that gives the building official an indication of the state of the building, how it's aging, and whether or not repairs are necessary. And he knows to expect then a phase two to come in. And that, as you say, Ron, could require testing, destructive or non-destructive, and could also require additional probing into the building components that are available. Remember that on a building, not all members are available for testing, especially the interior columns.
Correct. Next question.
Okay, let's see. All right, so we talked about, I'm just closing out some of these, asking if it's going to be in model chapter 1 or somewhere else. All right, can extensions to the 180 days be given if architects or engineers are not available?
The statute doesn't talk to that. It doesn't say that you can't. It just gives the 180-day hard limit. Here in Miami-Dade County, we did put extensions into our local ordinance, which is the value of creating your own local ordinance that you can define an earlier submittal time. For example, the initial, instead of the initial submittal being at 180, you would put the initial submittal at 90 days. That would at least give you some kind of a cushion to allow extensions. The extension that we accept here in Miami-Dade County has to be accompanied by an affidavit from the design professional saying that, hey, we've looked at this building. It is safe for continued occupancy while we complete these reports. so that we have an idea of the state of the building. Because at the end, the building official doesn't go out there, doesn't know what this building looks like, has never seen it. We are relying on the design professional to be the eyes and to be the determining factor of the level of safety for this building.
Which deals again that the local ordinance, although it's optional under what the statute says, is critical to a lot of these things. So you have the flexibility and the authority. So this is something you need to discuss with your local attorney as far as your county or city attorney. Maybe it's an amendment of your current ordinance, but it is highly recommended. Next question.
Where can the building department gather the information to determine what buildings in their jurisdiction is a condo or a co-op?
Gee, that's why DBPR is asking for that information, because the statute is required the condo associations and the cooperative associations to furnish by December 31st all that information to DBPR. And that DBPR in turn is going to make it available to you. However, I hate to say this, 180 days from May 26th doesn't quite work out to let you guys do your notifications so everybody can conform to it. But this is one of those funky little glitches that probably will be addressed. DBPR has not given us a time frame as to when they will have that database available. Remember, the deadline is December 31st, so you got to give them at least a little bit of time to make it available and post it, and then you can download it. This is an item that is pending with conversation with DBPR as to what type of database format they're going to use. Hopefully they will have one so they can be uniformly completed and be able to be downloaded. Next question.
Who can review the phase 1 report?
Review the phase 1 report. I don't get it. As far as the building department is not going to is going to check it out. I guess, sir, if you have a question, you would address the whatchamacallit, the architect or engineer of record who sealed it, correct?
That's correct. So who can review it? I mean, this has been placed under 553.899 statute, which means it's under the building code, which means it's under the building official. So any certified personnel of the building official, plan examiner, inspector, can review these reports. And if they have any questions, then they need to be referred back to the design professional who produced the report to clear up any ambiguity that the reviewer sees.
And this is, as Sergio said earlier, I think that it would be prudent for jurisdictions to create a template. Hopefully we might get one from the Florida Building Commission as a recommended template of a report to make sure that everything is uniform. As far as once the report is completed and let's say an owner wants to get it, the association of the co-op has to give those reports to the building owners or any prospective purchasers. Next question.
Please clarify how this is considered enforcing the Florida Building Code as far as fees are concerned, as this is not part of the Florida Building Code as of now, and the law just states the local enforcement agency is responsible. Is it possible this would not be a function of the building department? If repairs are needed to a building that requires a permit, obviously then they would need a permit and the building department acts as normal. Before that time, it could be argued that this is not a function of the building department. Your comments?
John, you are correct that the statute says the local jurisdiction. However, from a standpoint of enforcement and just the handling that paperwork, I would say 99.9% of it is going to be the local building department who's going to enforce this. This is a report that needs to be filed, that needs to be followed up, notifications need to be sent out. So therefore, there is a cost, and therefore, by ordinance, and again, going back to make sure you have an ordinance to back you up and set up the fees, that's where it should be. It is not in part, it's not part of the building code, but it does go back to the building code because it will require enforcement of some type. George, Sergio, you have a comment on that?
Yes. Eventually, it'll be by rule part of the Florida Building Code, which is empowered by statute. So currently, there's nothing in the statute that prevents charging a fee for services by a local government.
Sergio.
And as I just previously mentioned, this was placed under 553.899, which is the building code.
Next question.
Right.
Oh goodness, let's see. Will these certifications be addressed countywide or will it need to be per municipality?
Uh, I would say that you're talking about, like, for example, Miami-Dade has 30 something different building departments, if I remember correctly, Sergio.
35, yes, sir.
35. So I guess that it's going to be a local decision whether they say to Miami-Dade, or if you have multiple jurisdictions within a county, if somebody comes together and says, let's one guy deal with this. And of course, the county kind of makes sense in a way. But again, the statute says local jurisdiction. So it depends what their decision is. Again, go back, talk to your people, ask them these critical questions, including ordinances. And if it's going to be handed off to the county, let's say, and you want jurisdictions, smaller jurisdictions, have a conversation with the county commissioner so there can be a uniform methodology to apply this.
And if I could ask a question for Sergio, how is that handled in Miami-Dade?
I forgot.
Is that just the county that, or is it through?
No,
jurisdiction?
each of the 35 jurisdictions
Okay.
act independently, and we don't
Okay.
share information, although we are trying to create a countywide database
Mhm.
for transparency purposes with the cooperation of each of the jurisdictions. But each building official in each jurisdiction handle their own program.
Okay, well, that says a lot.
Which makes for more fun and more costs. Anyway, next question.
A building in Broward County had a report submitted in 2020. Is another report due in 2023 or 2030?
I think we need more specifics. So I would say I'm going to take an educated guess, so I don't leave that to George or Sergio. But if your report was due 2020 and you timely issued it, the only change would be that now the statute says 30 years with a 10-year renewal. So probably you would have to renew that in 2030. But contact Broward County. They would be more than happy to enlighten.
Ron, let
right.
me take a stab at that, because that's an important question too, because in Miami-Dade, we had to deal with that. The new law does not take into account that Miami-Dade and Broward had an existing program. So within our ordinance, we did say that those properties that have had an initial recertification prior to 1982, for buildings built in 1982, which would mean they were due this year in 2022 for recertification, they do not need, they can continue on the same timeline, which means if they had a recertification in 2020, the next one will be 10 years later in 2030.
Okay.
But that needs to be covered within your ordinance. So Broward County is probably working on their ordinance, kind of paralleling what they did, and that needs to cover in there. It's not a problem for any other jurisdiction because no one has done it in the past, so they start from a clean slate. But
right.
It is different.
Right. There was a little Q&A thing that somebody chatted with regard. Yes, there is a recording. This will be posted on the accessible legislative documents, and a PDF copy of the presentation is also going to be posted along with a bunch of other stuff. Next question.
All right. So, and then I just want to say we've answered over 30 questions and there are 39. It just went up. 39 open questions. So gentlemen panelists, if you would help me by looking over the questions as to the ones you feel are most important that we attempt to register to answer, but I'll go ahead and fire one out at you. Are government subsidized apartments considered co-ops?
Okay. Who's the legal department? I think they are, but I'm not going to, I don't practice law, nor do I do I portray an attorney online? George, do you have? No? Sergio?
Well, that's a good question.
Well, it all
Again, good
depends.
question for your attorney. You would think your ones that were controlled by the government would follow the path of this legislation if it is under the authority of the government, but I don't think the legislation is written clearly addressing
For that purpose. Sergio?
So remember that it depends on how they're being operated. There's only two modes that are covered by the law.
Yep.
One is if they're operated as a condominium under the statute 718, or if they're operated as a co-op under the statute 719.
So the
if it's-
statute covers both.
If they're right, if they're not operated as either one of those, then it's not a covered building.
But I think that if I remember, and again, this is just something I'm pulling from years and years ago. I think most of those under the county are typically operated as a co-op for some reason. Don't ask me why. I think it has to do something with the IRS or some classification. But please consult your local county attorney on that one. We're not practicing law here.
Is there a time frame from the time of phase 1 inspection to when they must have the phase 2 inspection performed when a phase 2 is required?
Yes, it's noted in the statute. You have 180 days, and after that, you must have the report, or else, again, as Sergio noted earlier, if you have a local ordinance, they can, if there's a mechanism to request an extension for a good reason that has to be documented, then they could extend it. But again, under the statute, there is a deadline for phase 2 inspection. Next question.
Okay, let's see. If there is a phase 2 report, the building official could use. If there is a phase 2 report, the building official could use that report to determine safe or unsafe and not visit the site. Is
Well,
that
there's no requirement to visit the site.
Mm-hmm.
There's no requirements for inspections from the building official. They completely rely on the report from the design professional. And if it's a phase 2, that means that there's most likely repairs required, and a permit for repairs will be necessary to be pulled from your local building official. At that point, under the permitting, you will visit the site for inspections. But if repairs are not required and a permit is not required, then the building official is not visiting. Of course, that's elected. That could be an elected from the local jurisdiction. They could elect to do inspections. That's totally up to them, but the law does not require that.
No, trigger. I'm going to hit 2 questions real quick. Jeff, with regards to the phase 1 report, the phase 1 report is done by a Florida licensed engineer or architect. And then the report is reviewed by the building department. Okay, so the city has nothing to do with the phase 1 report. The association or co-op retained the services of the Florida licensed architect or engineer to do the phase 1 report, as well as phase 2 report if required. And the other one from Marfil, can the architect engineer that does a report act as a threshold inspector? We kind of touched on that. The answer is we have to check the statute, but I think we would say, nope, you got to be independent. If you do a phase 2 report and you show that what needs to be corrected, the threshold inspection requirements for a threshold inspector are different. Probably they do not qualify, and if so, they should be independent. That's the opinion. Next question.
all right? So what language should be included in the initial notification, or any notification examples available? And Sergio, is that in any of the documents from your county that was
We
shared
posted.
on the resources page?
No. What I sent to you to post was basically an outline for the building official of the implementing a program. But the county, both Miami-Dade and Broward, have template letters that we usually send out on the initial mailings, and then follow-up mailings that obviously are geared towards these 2 counties. But one of the things that a jurisdiction has to do is create a template letter for those initial notifications. I guess they could go to our website here, Miami-Dade and Broward, and download them and maybe model their own after from that.
All right. If a jurisdiction codifies an ordinance to include all buildings, coastal or inland, in the 25-year requirement, would the exact location of coastline be less significant?
Yes, absolutely. Now, if you're going to the maximum, which is 25 years, and you're treating it across the entire jurisdiction, you don't have to worry about where they're located, but you do have to do that through your local ordinance.
All right. So a 4-story hotel does not need to be inspected.
No, and neither does a 3-story apartment building that has a single owner.
Yeah. There's one question here that I want to address. The question says, so to clarify, single-family dwellings defined by the FPC are not affected by this, but the 25% rule goes away on them. You have, the bill covers two things. One is re-roofing, the other one is recertification. The roofing would apply depending upon the definition of, was it done in 2007, blah, 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 but not recertification as defined by the statute. Single, two-family, three-family, 3 stories, up to 3 stories. Okay. Are the questions posted here going to be addressed? We're going to try.
All right, so per the dates, anything CO'd between July 2nd, 1992 and December 31st is required to have their inspection done by the end of this year, correct?
Yes.
Mm-hmm. Is it going to be feasible? That's a big question.
Now, I'll add that it's the responsibility of the condo and the co-op association to have these done. So if the building official is not ready to send out notification, they don't need to wait. They have to act on by themselves. It's their requirement. They have this requirement to do that.
All right, where in the statute does it allow cities to adopt an ordinance for this?
That would be, I believe, if you're a local, is that like 125, something like that? Statute 125, 125, 160, something like that?
Yeah, it does say that you can, the local authority or the local jurisdiction can impose suitable fees for this purpose. So yes, you are on clean ground according to 4D.
There are basic provisions in the law for local governments to adopt ordinances but I guess you're talking to this subject matter only. I mean, I think it's in chapter 125, but also in chapter 553, it allows the local building department to adopt administrative provisions for administering your building codes, including existing building code and your maintenance codes.
Right. So remember, the statute only added this. It did not delete that availability for the local jurisdiction charge. So you're still on firm ground. This one question by Anonymous, I'm not sure I understood, but it was stated that engineer that performs phase 1, 2 report and inspections cannot serve as the SI during construction. That is, I'm assuming during repairs. What about the same firm? Then he goes on about inspections, etc. What we were commenting was the requirements for a special inspector differ. And if you have a typical architect or engineer who is not accredited and credentialed as a special inspector, they cannot do those special inspector. As Sergio was commenting that if it's 4 or more stories, that is a requirement that has to be an SI as far as doing the inspections. I guess that if there was a SI who did the report and then wanted to be the observer for the SI inspection, I think that would be a conflict. I don't know if there is really a statute or an engineering opinion from the board, but I would say that's definitely a conflict that would concern me personally about that particular situation. But again, you have to go into the statute, you have to go into the regulations of the Florida boards, whether it's the architecture board or if it's the engineer board who credentials the SI. So that's critical. So I'm going to leave it at that one. And pick one.
Are apartment buildings not affected by regulation?
That's correct.
Apartment buildings, no.
Not really, but okay. Next
All right.
one.
What about a condo dash hotel?
If it's a co-op or a condo, yes.
Is a 4-unit, 2-story simple townhouse building required to perform a safety inspection?
We touched on that already. The answer is no.
No. Okay. How is story determined? By the building code definition?
Ground is 1. The one above it is 2. The one above that is 3. So if you have a parking below, that is still the first level. 3 stories, doesn't matter what's below. Remember, we had this conversation not too long ago, and you're doing a visual structural inspection. If the building above is getting supported by the parking deck below, you're triggered. You got to inspect it. You have to do a phase 1 because that's holding up the building. So that's a nice try, but no cigar. Next one. Oh, will recertification be expanded to apartment buildings, hotels, office buildings, parking structures, etc.? I'm not an attorney, nor do I portray one, nor do I put myself out to one, but I have the minority opinion that this is going to happen. However, as both Sergio and George have expressed, the title is condos and co-ops for this particular bill. But I don't feel, personal opinion, not of the BOAF or anybody else, I think that's going to come up. Next question.
Well, I was going to say we've been on this call for an hour and 15 minutes, and it
You want to
seems
give it
like
5 more minutes, and
well, I was
then
gonna
we'll
say,
wrap
it
it up?
seems like this is the beginning of the conversation. And so do you think the legislative committee will plan more webinars like this as time moves on and we learn more?
We have discussed informally that we feel that this subject, as well as another one that is unresolved, will require additional information for both BOAF members and other members of the AHJs to be aware of. And yes, we will be looking at that. Probably, I would say that because we are asking both the Florida Building Commission, it's doing its work with its work group, as well as the legislators to do some clarifications. More than likely, this will be sometime in, I would say, September, where we may have scheduled another one. However, please send us an email that you want to be notified. We'll be happy to notify you. It'll be the same sort of format with whatever new information we can get. And do you want to give 5 more minutes for questions and then wrap it up?
Yeah,
Well, yeah,
I would say
but
also that I'm sure it'd be extremely helpful. We're getting many positive comments over this type of, and will be helpful in making enforcement action uniform throughout the state by setting up these webinars.
All right, gentlemen, if y'all would look at that Q&A tab at the bottom of the Zoom panel and just scan over some of those questions to address the ones that maybe we do need to wrap up, as we're winding down here.
All right, somebody question, will this be a new permit type and who will be able to whatever? I'm assuming that as far as roofing, as George noted out, you can modify your existing roof permit and maybe put a supplemental sheet to it. As far as phase 1, phase 2 inspections, those are reports by a licensed individual. And of course, if there's repairs, let's say there's structural repairs, concrete repairs, there's roofing that would require electrical work, those are existing permit categories. So as far as I can't think of a new permit type that would need to be created for that particular type of a situation. Intercoastal waterway relate to the coastal defined line. Oh, if it goes out to a body of water such as the Atlantic Ocean, yeah, coastal definition could kick in. This is what Sergio was attesting to earlier. And I think that we have to leave it at that kind of needs to be defined. I wish we could use like US 1 as the nice marker, but that's not going to work. Do you know if DBPR has started a database for these buildings? And if yes, how it can be accessed? The information is due to the DBPR, Department of Condominiums, et cetera, by December 31st. They have not told us anything with regards to when they expect it to be able to be accessed, but until they have it, they can't give it to us. And we're hoping that it's an Excel format. However, if people are late, such as the associations, we'll probably be seeing updates with regards to it. Is the state going to be enforcing the association report? Who is the state AHJ specifically? This would be the Department of Condominiums and Co-ops under the Department of Business and Professional Regulation. It is not the responsibility of the local authority having jurisdiction to enforce that. However, if the phase 1 or the phase 2 reports are not filed in a timely manner. That's why we said you need to modify your particular local ordinances to create a means to leverage and enforce that to be filed, phase 1 to phase 2 reports. We normally receive a list from Broward County telling us which properties are required to be recertified. Do we need to wait for this list for the new milestone recertification? We are a local municipality. Talk to Broward County. They'll probably give you the list. Broward County, Dade County have the databases. They've been doing this for years. So guess what? You guys are in good shape. It's everybody else that's got a problem. Okay, about the 4-story versus 3-story. If it's a 4-story and it's a co-op or a condo, you are required to be recertified. If you are a 3-story and it's a single 2-family or 3-family dwelling, you have an exemption. That's what the statute says. Okay, I'm trying to go real quick, guys. Will DBPR provide you a checklist for inspection? No. You have to create your own. Hopefully the Florida Building Commission may come up in their work group with a template, but we don't know if that's going to happen or not. Should engineer reports include certification statement per fact 61G 15-18.011 sub 4, and architects don't have a similar certification requirement? I tell you what, I think that more likely the engineers will use it. I think that the E&O insurance carriers or the architects and engineers, I'm probably going to tell them they're going to have some specific wording on their report. But that is outside the purview of the statute or the AHJ enforcement. Okay, anonymous 553.899 section 1213 suggests recommended criteria for possible inspection not to be completed by the FBC and then the Safe Fire Marshal Association. What criteria should be used before that date? Basically, those are recommendations to the state. They're not criteria for inspection, so be guided by the statute. And I think Ann's telling me that it's time to give up for the day. I'm sorry, I'm trying to be quick about it.
I'm just telling you, thank you, Ron and Sergio and George, and to the 171 attendees that are still
here
on the webinar right now. So
yes.
Thank you. And we appreciate everyone being here. There's going to be a brief survey that pops up at the end. Please complete that, because that's going to help us to continue to bring you more of the content you want to see. And just a reminder, the information in this webinar is not a substitute for reviewing the legislative changes with your city or county attorney. And this has been recorded, and we hope to have it up on the website within, hopefully by the end of tomorrow. So thank you again.
Okay, and I have, excuse my lateness to do this, but let me put in the last of the slides. Hold on one second, boys and girls. Okay, reminder, this is general education, it's not legal advice. Please consult your local jurisdiction attorney for specific review and recommendations. Address the required updates, educate not only the contractors and the professionals, but also your staff. That's very, very key. There's going to be a lot of public that's going to have to deal with these. These are going to be on condo association owners, probably some of the board of the condo associations or co-ops. You are going to be the person that's going to access this. So your key line, frontline people need to be aware of what's going on and give them as much information and training as possible. Thank you for attending. Backing up on Ann, she has been her and Celeste, who is not feeling well. Thank you, Celeste. You were there for us. We love you. And
Thank you.
and the email address for your questions and comments is info@boaf.net. This will be posted as a handout, so you will have it with the links. And please ask questions. We may not have answers, but trust me, we will use your comments and those questions as feeder for the next webinar to try to address as much as possible. Thank you for your time. Thank you for attending. Thank you, Sergio, for your journeyman duties, as well as George Luis Hernandez, who gave us a lot of information but was not able to participate, and Ann, who has to put up with all of us.
Thanks. Bye-bye.
Thank you all.
Everybody out there. Thank you, Ron.
Bye now.
Thank you,
Bye-bye.
Ann.